Welcome everybody to today's WILG webinar on CMS's new strong guidance on non-submit MSAs and what does it mean. For those of you who don't know me, my name is Tom Holder. I practice law in Atlanta, Georgia with Gerber and Holder, and I'm a past president of WILG. Our two guests today are Paul Sighinolfi. Paul is the Senior Managing Director of Ametros, and prior to that, he was the Chair of the State Board of Workers' Compensation in Maine. Thank you, Paul, for joining us. Our other panel today is Ryan Weiner. Ryan is the COO of Massive, and Massive prepares MSAs. We use them when we're not happy with the MSA that's being presented to us by the defense. They also create MSAs and work with future medical assessments. They also help resolve medical liens, so they can help us in a lot of different ways in our cases. I'd like to thank Jennifer Comer, our CEO. I think this is a real testament to the strong relationships that Jennifer's worked hard to create with our partners, Ametros and Massive, and the people in WILG. We've been able to pull this together in one week, which is really quite extraordinary. And as usual, we'll help keep WILG lawyers ahead of the curve on the hot topics in the workers' compensation realm. I'm sure many of you know when we started with seeing evidence-based and non-submit MSAs a few years ago, the WILG lawyers knew what was going on even before the defense lawyers who were trying to get us to accept them. So it was really nice to have that information in a timely basis. One thing I do want to just mention is that there will be no CLE credit for this. There was no charge. This is a value add to your WILG membership. And we were unable to arrange for CLE credit that quickly. Also, if you have any questions, please send them through the chat and they will be filtered through to me. We will do our best to get to them. I also say if you really want your questions to go to the top of the ladder, my Venmo account is tom-holder-1. And if I see on my phone that anything's sent through them, I'm sure your question could be answered quite quickly and we'll get right to it. So we're going to turn it over to Paul, and Paul, you can let us know what's going on, and we look forward to hearing what you have to say.
Thank you very much, Tom, and I want to thank WILG for giving us the opportunity to do this presentation. I want to reiterate Tom's comment about questions, though. This is an area where we think there'll be lots of questions because it's such an imprecise area of the law. If you're looking for black letter law today, I think you're in trouble. If you're looking for some advice and guidance, I think you're going to be okay. So let me set the table, so to speak, about this presentation by giving you a little bit of background about the whole MSA process. So we have Medicare passed in 1965, and in 1980, members of Congress became concerned about the fact that Medicare was being spent on things other than what were Medicare related, but rather for things that were associated with workers' compensation cases, liability cases, and other areas where people should have insurance. And so they passed the Medicare Secondary Payer Act in 1980. And that's really the threshold legislation for everything that flows in this presentation today. For the most part, and I was practicing not in 1980, but sometime shortly thereafter, for the most part, people ignored that act. There was not much done to protect Medicare's interest until Mr. Patel came along in 2001 and he wrote this memo. Patel was a businessman at CMS, and he was charged with trying to figure out why they were burning through as much cash as they were. And Patel essentially told his brothers and sisters in that organization, listen, what's going on here is that we are not becoming a secondary payer, but rather a primary payer because people are neglecting their responsibilities. And one of the ways their responsibilities can be perfected is to develop a thing called an MSA, Medicare Set-Aside Account. And when he wrote that memo, he used the word trust, Medicare Set-Aside Trust. And I think what happened in the early legal literature on MSAs, there was a lot of discussion about having to have a trust. Ultimately, we learned that you don't need to have a trust, but rather you simply need to have an account that is dedicated to pay for future medical bills. Following up on Patel's memo, a whole series of memoranda came out of CMS on how to do these things, how to handle these things. And some of the memoranda actually were written in the form of frequently asked questions. And that began in 2003. As a matter of fact, I was back in very active practice back then, and I pulled up a notebook that I kept, that every time there was a new memo, I put it in the notebook to keep myself posted on what was going on with MSAs. And then beginning in 2013, CMS came up with what they called a workers' compensation Medicare set-aside arrangement reference guide. That was the first guide. It was version 1.0. And that, the language in that superseded all of the earlier memos. And that was the guide that really set the stage for how to do MSAs correctly. In the very first guide, in the very first point in the guide, they tell us pretty clearly that there is no statutory or regulatory provisions requiring that you submit an MSA amount proposal to CMS for review. If you choose to do it, however, you please comply with our guidelines. And then later on in the guide at 8.0, they essentially say the same thing. There's no obligation to submit, but if you do submit, you should do it in compliance with what we tell you to do here. So all is well, no need to submit, and as a result, people started coming up with an instrument called evidence-based MSAs or non-submit MSAs. They were either evidence-based, or we had some law firms actually giving opinions on MSAs that essentially said you don't need to submit these things. Well, a week and a half ago, CMS came out with a brand new directive 4.3 in the guide. And Tom, if you could flip ahead to not our first slide, but the second slide. There is the language. This is what CMS is now telling us. And essentially, this is what prompts us to have this discussion today. They're telling us that CMS is going to treat these as if they are attempts to get around the obligation to protect CMS's interests or Medicare's interests. So let's go back to the original slide and start talking about. Okay. So CMS includes a paragraph.
If I can interject real quick,
yes,
I just want to make sure everyone's aware. The idea of a non-submit MSA and an evidence-based MSA, these are specific marketed materials by, for the most part, defense-oriented organizations who are working with your opponents. They are not just MSAs that aren't submitted, but rather they're designed to be lower. They're marketed to cost a little bit more money to the carrier, but to set aside much less money for the use of potential Medicare payments. So they are specific marketed materials as opposed to just a lowercase term. They're uppercase non-submit MSAs, if that makes sense.
We actually found when they were first being presented to us, the lawyers on the other side didn't even really understand the implications of what they were trying to do. And it was nice to be able to point out what was actually going on.
Yeah, Ryan and I had a discussion about this yesterday. And the idea that you can look at somebody's medical situation at the time of settlement by looking back at a couple of years of their medical records and a couple of years of the medical costs associated with treatment, and run those forward for the rest of their life expectancy, assuming they're going to be in some kind of treatment during the course of that entire time, and come up with a precise number, really doesn't make a great deal of sense, but that's what this process is about. So CMS includes a paragraph last week at 4.3 that indicates that they do not recognize non-submit MSAs. And there's some feeling in the community as to whether or not that was a blind side or whether that was something that was anticipated. I know, Ryan, you have some feelings about that.
I do. I think this isn't really too much of a blind side. For a long time, Medicare has suggested quietly, not officially, that they don't accept and they don't agree with the idea of a non-submit or evidence-based MSA. For the most part, they've mentioned they look at it as improperly shifting the burden to Medicare from the carrier. That's because that's how these are marketed, as I mentioned. So it isn't a huge change from my point of view. It's just that they're publicly saying it now, and that makes all the difference to me.
I think part of the message that we're getting from CMS is this: we know that these are out there. We know that people have been marketing them pretty actively, and we have seen a drop in the number of submissions that have been sent to us. So we know, in a very real sense, our data demonstrates that something's going on. And it's almost as if they've decided that at this point, what we're going to do is going to do something about that problem. Because although we're sending you the message, you don't have to submit. We really want you to submit. Agree, Weiner?
I agree. And when they say they want you to submit, they are suggesting, hey, this is safer. Do this and you'll be protected. This is the only way to get a so-called safe harbor. It's the only way we know how to deal with it. And clearly they haven't thought of any other ways in the last 25 years. So I think this is why they're being so aggressive. They know it works for them.
Our next bullet point, I think, is right on point. And that is, this is the most aggressive step CMS has taken to emphasize submission and their ability to deny post-settlement payments. If you harken back to my history a short while ago, there's nothing in those earlier memos that was anywhere near as aggressively being stated. One of the issues that's being discussed amongst those of us who deal with MSAs on a regular basis is, what is the legal authority of the reference guide? We know it's not the statute. We know it's not a regulation that's gone through the Administrative Procedures Act process federally, but we know it's the guidance that we're receiving from the agency. And I think as a result, there's some question about what do we quite do with this stuff? Ryan, do you want to weigh in on that one?
Sure, a couple points. One is, I don't think that much has changed. Again, Medicare didn't like these before, they just weren't public about it. So what we have is really a warning, and it's them publicly saying, stop doing this. This is how it's going to hurt you. But at the same time, ignoring whether or not they have legal justification. The penalty comes down to, are they going to find out? Are they not going to find out? And how do they find out? And really the answer is, if there has been a non-submit MSA, or you just didn't do an MSA, the real penalty is Medicare says, we're not going to pay for treatment. They're only going to not pay for treatment if treatment occurs. So really you're looking at a scenario where if there are future medicals and you've taken care of them, there's no risk.
In anticipation of this presentation, we met the other day, and Tom raised a very interesting question. How does CMS really even know that a case has settled? And the answer to that question is that there's a section 111 that insurance carriers have to comply with. And what they do is, if it's a workers' compensation case where they're paying benefits and somebody is Medicare, is on Medicare, they will be filing those documents on a regular basis. But in every case, they file those documents at the time of settlement. And what does that document tell CMS? It tells them the name of a party. It gives them descriptive information about that party, not the least of which is their social security number. In addition to that, it provides, using DSM-10, a description of the nature and scope of the injury. So for the last couple of years, I've been saying to attorneys, how often do you request to know what they filled out on that section 111? Because that is the benchmark against which CMS evaluates whether a medical treatment should be paid for by the workers' compensation money or should be paid for by Medicare. So they describe the injury using DSM-10s, which ICD-10s, I should say, which are really very, very precise. I don't know if any of you have ever looked at those codes. And then they say how much the settlement was. And when they say how much the settlement was, what they say essentially is what the gross amount of the settlement is. They do not give a breakdown. This is important for you to know. They do not give a breakdown between what is attributable to future medical and what is attributable to future indemnity. It's a gross number. And so what CMS is now saying with this new 4.3 is that the entire sum of the settlement, less procurement costs, and I think you guys are the procurement costs for the most part, less procurement costs is exposed to a set-off for any ongoing medical care. Ryan, would you
So
agree?
I have a question about this. So Ryan, did you have something you wanted to add? Let me ask my question.
I do. One really important thing about Section 111 reporting, in addition to the coding that is important and the settlement amount that's important, your information is reported. The defense will report who the plaintiff attorney is. So they know who you are. They may come after you eventually. There's no mechanism for that, but they do know who you are.
Let me say one other thing about Section 111 filing. Do carriers take this seriously? And the answer is they take it very seriously. And why do they take it seriously? It's a $1,000 a day fine if they do not file those documents properly. And so you're looking at a fine of $365,000 a year per violation, per case, if they do that. So that becomes a real problem. Tom, you got a question?
I do. So I understand that in the situation where my client is already receiving Medicare, what happens in situations where my client has a likelihood of receiving Medicare benefits within the next 30 months and they're not on Medicare, they're not already getting Social Security, but maybe just for example, they've applied or they're 63 years old and we settled the case. How does Medicare know about them in that situation?
I'll answer, then I'll give Ryan an opportunity to clean up my answer. But they know because at the time of settlement, they learn about all the settlements, Tom. So you settle the case, they're informed. It's almost as simple.
It doesn't matter. It doesn't matter if the plaintiff is a Medicare beneficiary or not. Medicare reporting is supposed to occur. So you can be a 7-year-old who is 58 plus years away from receiving Medicare, and the information should be reported to Medicare under the rules.
Okay.
It has really sort of concerned me, Tom, that the bar hasn't paid close attention to these Section 111 filings because they are so important post-settlement. Because as I said before, they describe the nature and scope of the injury, but they also provide your name, as Ryan was saying. But in addition to that, they give a gross number. This case settled for, let's assume a case settles for, several $100,000, but the medicals are only $10,000. What would happen is that the several $100,000 would be up for exposure by Medicare. Okay. Any questions about that, Tom?
I mean, because one of the problems that we see, like I practice law in a state in which we don't receive any benefits for future medical, and we're just having more and more things piled on us that don't make us any money. And I mean, there is a time aspect to it. I mean, so that's something. So we've gotten a couple of questions. One of the questions is about the $64,000 question. That's an old school reference for us. So I'm going to throw it out there because this is a topic that we were planning on talking about. So I think we can change. Are we finished with the discussion of the Section 111 reporting, Paul?
Yes. Yeah.
Okay. So this is from Dylan Besser, and this is the question that we've been talking about all along, which is, what happens if you have a settlement below the threshold for CMS review and there's a non-submit MSA, right? A $200,000 settlement plus a non-submitted MSA for a claimant who is, who hasn't yet qualified for Medicare, or a settlement of under $25,000. And on our side, our concern, what is our risk there with not submitting it? How do we knew? The question here is, does CMS view these MSAs as ignoring their interests? So I think this is the question for people on our side. This is obviously the big question. So I figure we might as well just go right to that topic.
Really, guys, don't fool around. You go right to the heart of the problem here. Here is the difficulty. These numbers, the $25,000 and the $250,000, depending on whether you're collecting Medicare or whether you're going to collect it within 30 months, are workload threshold numbers. And what does that mean? It means that CMS has a contractor, and they're only going to burden the contractor to consider cases that fall within certain thresholds, because at some point, and I went back and looked through the data, they've had this number for a long time. At some point, their data said this is about all they could handle. If these cases flowed in as we're going to predict, this is all they can handle to do the job well. And one of the criticisms, by the way, of submitting for the longest time was that you would submit and it would be 9 months later that you'd get a reply. And so that was one of the big criticisms. That problem has gone away. Here's the difficulty, Tom. If you were to submit, say your $200,000 case, and we'll rope in Ryan's comment earlier about somebody who's in their mid-30s. If you submitted that, they wouldn't even consider it because it didn't fit with the parameters of their workload threshold. So you're stuck in a situation where you can't submit because they won't take it. So what do you do with it? And I think the prudent advice is, and I'm sure Ryan will correct me if I wander too far, I think the prudent advice is to make sure that you somehow paper your file, that these were the factual circumstances at this snapshot in time, the time that we're settling the case. This is what the numbers look like. This is what my client looks like. We're trying to take Medicare's interest into consideration, and this is the way we did it. And you document very carefully at the time. And then what you do is you have your client, if they're self-administering, carefully monitor all the bills that they paid, make sure that they pay the bills consistent with any fee schedule that exists in the jurisdiction, and that they pay them in the for correct CPT codes, and that they keep track of every single one of those. And when CMS comes knocking at the door, they go in on bended knee and say, this is what we did and this is why we did it. Ryan, what say you about that?
I agree with that. You need to paper your file. You need to act like there's an MSA, even if Medicare won't accept the MSA. Paul, you mentioned to me privately, there's thoughts that the review threshold will be lowered. We think that makes sense. The contract that was issued 4 or 5 years ago seemed to indicate an expectation of greater workload. On top of that, I think there's a new contract probably due soon. I think it was a 5-year contract, so I imagine there might be a new reviewer soon. Don't quote me on that one.
Yeah, and we should tell those who are listening that this Medicare Secondary Payer Act applies to liability cases.
It applies to all cases.
And unfortunately, unlike workers' compensation, CMS has not come up with guidance on how to properly put together a liability MSA, and they won't even accept liability MSAs if you want to submit them and say, is this okay? And so I think that that's a market that is going to be exposed at some point, and we have some reason to believe, for those who are listening to this presentation, we have some reason to believe that CMS is going to come out with something about liability MSAs as soon as next month, as soon as February.
So that's actually only in 4 days. That's very soon. It could be mid-February, we don't know, but it could also be early February. The important thing to think of here is what the Medicare Act really, the Secondary Payer Act really says. And it just says that Medicare cannot make payment on your case-related items. Someone else should be making it, Medicare won't be. What we do have, though, is Medicare has to receive a payment request. So if you do have an MSA in place, probably a real one that is not ignoring other future care that a specific marketed NS MSA may do, you're more likely than not okay. So as long as you go through the process, Medicare doesn't receive bills, there's no damage that can occur. And that's really the best safe harbor that I can come up with. At the same time, you look at how defense is reporting, and Paul mentioned there are very, very specific codes for ICD-10. Make sure that they're reporting narrowly. It's not arm fracture. It's left lower arm fracture. Be very specific and make sure they're being specific. And that will narrow your risk. On top of that, having an MSA in place, even if it's not reviewed by Medicare, further narrows your risk. The only real risk is if Medicare says this should have never came to us. At least then you have a unsubmitted MSA where maybe there's funds available to cover it instead. You're going to be burden shifting a little bit for yourself, but there's a little bit of a fund there just in case. Various treatments may never occur, so you do have that in place. It's simply do your best to make sure Medicare will not pay for anything.
I think not to be, you know, a gloom and doom. I don't want to make this a gloom and doom presentation, but I think it is within the realm of possibility that some of the evidence-based MSAs are going to be okay. The problem is you're going to have to go through the process at some point. If CMS starts questioning payment, you're going to have to go through the process of demonstrating to them that you did things properly, the numbers are good, and that you were not trying to shift the burden. And I think that's going to, Tom, I think that's going to be a real difficult area for injured workers who are trying to do Medicare set-asides themselves, self-administration, because the documentation, it has to be there, and the documentation is not easy. They have to demonstrate that using only one account, that it's a dedicated account that they put that money into, and so you can demonstrate a very clear paper trail. But I don't want to say that those things are all going to fail, because I don't think that that's true. I think that some of them are going to be able to be defended and be okay. The problem is you don't want to have one of those be one of yours and have your client come knocking at your door and say, Tom, please help me out here. I've got Social Security or CMS knocking at my door saying they're not going to do things. Let me give you a little bit of history about me. When I was a regulator, I worked for a governor. I worked directly for the governor, and my job was to run the workers' compensation system in Maine. And I would get phone calls from people who were subject to a random audit by CMS, and they would call and say, I settled a case. When my case settled, I have this thing called an MSA. I have an obligation to pay things in a particular way. Social Security has contacted me and said that they're not going to pay any of my Medicare bills going forward until I explain what I've done and why I've done it. And I don't have the ability to do that. Can you help me? And my response to that question was uniform at the beginning. And that is, you're going to hate what I'm about to tell you, but the answer is I can't help you because we lost jurisdiction. Here is my recommendation though, go back to a lawyer. And invariably what I would hear is I've talked to my lawyer and he or she doesn't know much about this and said they really can't help me. And that's how I ultimately discovered Ametros, because I knew that Ametros would come in after the fact and try to do the best they can to sort these things out. But that was a real problem because I didn't, you know, as a regulator, I didn't know what to do. And most of the attorneys who are in private practice in situations like probably most of the WILG members who are listening to us today don't know enough about the intricacies of CMS to walk down that road. Ryan, have you seen any of those situations where people have had Medicare actually say they're not going to pay anything?
Where Medicare refuses to pay for claims?
Yeah.
We haven't. It's usually beyond when we're involved in the case. That's, to be honest, something I had to defer you on, actually. We've heard of it, and I think I actually was looking at your website the other day, and you guys did a study showing those kinds of denials. But I'm leaving that to you. That's your wheelhouse.
Okay. Yeah, that's the other thing. We just published a white paper where we did a Freedom of Information Act request to CMS to find out how frequently they were actually denying payment. And what we discovered is over the years 2018, 2019, and 2020, on average, somewhere in excess of about 30,000, or actually 34,000, I think, people had bills denied by CMS who had approved MSAs. And the reason for that is that something was going wrong. The bills weren't being properly submitted or something. Why don't we skip ahead?
I have two things. One is my connection's going out a little bit, so that's one reason why I've had to click off a couple of times, and I apologize for that. The second thing is you're using the 34,000 number as number of rejected MSAs or MSAs where there's been a contest. What would you say?
Those are situations where bills have been submitted on behalf of somebody who has settled their case with an MSA, and CMS or Medicare has gotten the bill, and they've said that's not ours. We're rejecting it.
And out of how many?
That was the question that Ryan asked me yesterday, and I didn't have the answer to that, but I will provide you with that answer you can share with your members.
Well, obviously, if it's 34,000 out of 35,000, that's one thing. If it's 34,000 out of 35 million, then it's something very different.
That's
But
individual claims.
The important thing is it's certainly enough that it is a concern. And I mean, just following up on that, I have cases where defense lawyers will just say, we're just not submitting it, for whatever reason. They just don't feel like it, or, they're told not to. And then, of course, we're in a situation where, we might be told we can't get the case settled if we insist on it being submitted. And where does that kind of leave us? Where does that leave us?
I have pretty strong. Excuse me. So I have pretty strong opinions on that question, Tom, where I think CMS is specifically telling you can't allow that to happen. I know that may not be a helpful answer, but because CMS is saying we don't accept these, you're shifting the burden. Defense is asking you to do something that will effectively hurt your plaintiff or your claimant. I think they're saying that they're trying to tell you this is unethical. This may be even considered malpractice because we may not pay for something, and then your client's on the hook. This is a new thought, and I don't mean for it to sound so strong, though I think it is. Right now, if you ask me that question, I would say I don't know how to tell you to settle that case other than to say there must be an MSA that must be submitted, or there at least must be some kind of MSA in place to protect your client. That's where Medicare is pushing us right now, is to tell you that sounds like a situation where defense is saying, be unethical, commit malpractice. And you have to make a decision based on that. And I apologize that I don't have something easier, but that's where we are.
Well, do you think that, maybe, I think as always, the 61 people on this chat know a lot more about what's going on with this than our adversaries. So, I mean, it might be a time where we could say, there's this new reference guide. There's a lot more going on in this area. Look at section 4.3. It's really going to be problematic. I mean, at least it gives us something to say. So I thought that might be something too. I got a couple of questions. So
let me answer that question now too. I'll weigh in with Brian. I'm in total agreement with him. I think at this point in time, knowing what we know, we may learn more in a week or two or 10 or at some later time that tells us that CMS has not taken steps that appear to be quite as draconian as 4.3 suggests. But I think you're in peril if you say, don't submit. That's okay. I can live with that. I think you're putting yourself on the line. And, I think your obligation is treat your client like your best friend. If it was my best friend, I'd have that submitted in every single case.
Do you think we're running into risk on that? I'm sorry, I cut off before when you were answering the question about the ones below the threshold. Do we have that same possible problem in the below the threshold cases?
Well, the problem with below the threshold is you can't submit. That's the rub.
Right.
They will not accept it. If you sent it in, they'll send it back. Ryan, is that correct?
Yes, that's correct. I agree. I think your options with below the threshold are, number one, we are hopeful this threshold will go down. And number two, some people actually work creatively to get below the threshold. Stop doing that. That cuts out some of them. So instead of settling for $24,999, you'll settle for 25 plus. Number one, you'll get more money and more money for your plaintiff or claimant. And number two, you'll be in a safer scenario. The other issue is when it comes to threshold, again, it's just threshold. So if you do an MSA, and regardless of where you are in the threshold, you may be protected in some way, enough that Medicare doesn't get a bill, you're fine. It's all about Medicare not getting that bill. And finally, maybe not threshold related, but if you can get a note from a treating doctor, not a biased individual. So no IME, I know they're biased the other way, but no one like that. None of your hired guns either. If you can get that note from the doctor saying no future treatment, I don't want them to say no. I don't want them to say, excuse me, MMI. I want them to say no future treatment. If you have that note, you've got protection. You are in good shape, no matter if you settle for $1 or $1 million.
Okay.
I agree, but it's dangerous. And I think the issue, Tom, is If you can't submit, you don't submit, but you protect yourself in the fashion that we described earlier. But if you can submit, you submit. I really believe it's as simple as that.
Okay. I mean, but of course, the practical matter.
Froze.
We're losing Tom again.
Why don't we continue on? In the final bullet point on this particular slide, I can tell you that our company is already seeing attorneys, vendors, and others following CMS highly recommended guides more closely as it relates to submission and engaging in professional administration. The advantage to professional administration, and I have to candidly admit that's what I presently do for a living, is that we know how to do it correctly. We document things properly. We pay consistent with fee schedules. We use a dedicated account. So we do all of the 6 things that CMS wants you to do with a Medicare set aside. And so when it comes, when a question comes from CMS, is this properly exhausted? We can demonstrate how, in fact, it was properly exhausted, as opposed to the individual who doesn't understand all of the things that they have to do, isn't particularly crazy about keeping records in a particular fashion, hates doing these things as much as they hate doing their taxes. So they're not doing them properly or as thoroughly as they should. Ryan, without Tom, you want to comment on that?
I have no agreement. I have no disagreement. Excuse me. I agree. I actually find it to be worse than taxes, and that's why we're leaving it to you guys to administer. I also don't do my own taxes, but the professional administration, even if it's a non-submit MSA, which you know my thoughts on non-submits. I don't like them. But if you have professional administration, it may be easier to comply with the Medicare exhaust issue later on. You can at least show them there's nothing left.
Yeah, we have non-submits on our platform. We have some people who are non-submits. And in addition to that, most of the cases that we're administering presently are in fact submits. So where is Brother Tom? Is he coming back? We need him to advance the slides.
Well, we'll find him later. Actually, I think your team can advance the slide.
I was going to ask that. Melissa or Melanie, can you?
There we go.
So there's the language. These slides will be available to you, so you'll have the language. My recommendation is that you, in fact, get yourself a copy of the updated reference guide. It's not a bad thing to have if you're going to be working in this area and you're representing clients who are going to bump up against Medicare set-asides. Tom, could you advance to the next slide, please?
I'm sorry, yeah, that's Melissa. And I apologize again, I lost my connection. Okay, I'm sorry. All right, that's it.
All right, this is a slide that essentially tells you what the non-submits are. It's a quick refresh. Submission of MSA to CMS continues to be voluntary. That's sort of the irony of this guidance, is that you do this voluntarily, but if you don't do it, this is what we're going to do. These MSAs forego submission to Medicare for approval. Initially, they were mostly to speed up settlement. So there were 2 problems in the past with MSAs being submitted. The principal problem was it took so long. I had cases that hung out there for 9-10 months before we got them back. And my clients were anxious to settle. They wanted to move the case forward. They wanted to get the hell out of the system, and they couldn't because we were waiting for CMS to get back to us. The second big problem was, and this is what I think the evidence-based we're trying to solve, is that frequently they came back with much bigger numbers. One of the large insurance carriers told me that if they looked at the average of what came back from CMS, there was a 6% increase. And 6% doesn't sound like a lot, but you spread that across thousands of cases and it turns out to be a big number. And so that was the second reason that there was some objection to submitting. In recent years, the allocation methodology has been different from CMS, mostly obtained lower projections. So it's basically doing it based on evidence-based medicine. Next time you're taking a deposition of a doctor, say to that physician, what's evidence-based medicine and how often do you employ that in the course of your practice? And what you'll learn is that that's essentially the standard these days of practicing medicine. You find what the best evidence of the best way to treat people. I suddenly lost you guys.
We're here. I'm good. Can you hear me, Paul?
I can hear you. Okay, got it back. You know, as we were saying earlier, Tom, even if you wanted to, what's happened is that some of the evidence-based medicine Medicare set-asides, they were submitting them to CMS, essentially saying, we didn't comply with your methodology, but this is what we've done. We want you to track this. And I think we have seen some documents that have essentially suggested that CMS has sent that back saying, not properly done, we're not going to consider it. So,
well, of course,
there's some caution.
Yeah. Go, Ryan, I'll go after.
I would advise some caution when it comes to the term evidence-based. I think it is a real medical term. I think the use of it in evidence-based or non-submit MSAs has been co-opted a bit. I don't think it's necessarily looking at true medical practice. I think it's again, how have these things been marketed? They've been marketed to reduce the amount of MSA. So they may be co-opting the term to make the MSA smaller, which has its benefits if Medicare agrees. But if Medicare doesn't approve it, it looks like a burden shift, which is why we're here today. And that's a real big concern. Be cautious with using the term evidence-based in any way that you think may be helpful to you.
I completely agree, because also, like, in our state, we don't have evidence-based medicine. So when someone comes in and says that, you know, that's not the standard for our standard of medical care is necessary and reasonable. So that's not our standard. And of course, to me, the biggest thing is, as we all know, one of the reasons why we settle a case is so that our clients can start having more freedom of medical care, choice of doctor, which they don't have in a state like ours, which is employer medical choice. So, you know, I just say, you know, you're asking my client to trade one master, the insurance company, for the other, the MSA administrator, and, you know, we just won't go along with it. Paul, one thing I was asked is, would Ametros administer a non-submitted MSA?
yes. As a matter of fact, not only will we, but we do.
Yeah.
I'm not sure what we'll be doing going forward. We have to talk about that internally, but I can tell you that we do have non-submits on our platform as we're sitting here. I can tell you that my impression is that the ones that are coming in now post the January 10th are ones that are in fact not evidence-based, but rather they're ones that are being submitted to CMS. Okay, and I would echo Ryan's comments a short while ago. Early on in my career in workers' compensation, I had one of the judges tell me that workers' compensation is a medically driven legal system. And so the interplay between medicine and medical care and the law is much more intimate in workers' compensation than it is in, you know, liability cases, because everything involves an accident. You know, everything involves somebody being injured at work and because of their work. So why don't we go to, oh, Tom's, he's gone again. Ladies, could you, okay. Okay, Medicare Visibility, Medicare Systems Capture, and this is what we were talking about at the very beginning, Section 111 data. Means that CMS has information related to total obligation to the claimant, the total settlement allowance. In Section 403, they talk about total less procurement costs. If ongoing responsibility for medical care was extinguished, that's what Ryan just said a little while ago. If you have a primary, I think it almost has to be a primary treating physician, Ryan, for that particular injury, step forward and say, medical care is over. This person is as good as they're going to get. The treatment doesn't need to go on any further. So it's a zero MSA. And I know that there's been some controversy with those in the past. Ryan, have you ever been involved with the submission of a zero-based MSA and had CMS respond?
You know, we actually haven't done any zeros. It's not generally what we're involved in, but I like the idea of them, and I'm encouraging them. We are recommending them going forward if you can really get one. And that's how we think you can deal with the certain issues of, does this person actually need treatment or not? There's a time for a zero, there's a time for $1 million MSA. And we certainly agree with the idea of them, but submit it. I don't believe a non-submit or an unsubmitted 0 is a real MSA. And I don't believe that this person doesn't need future treatment. So if they don't need future treatment, let's get it locked in. You never know what's going to happen next year.
Yeah, make sure your doctor writes that opinion with a straight face and a pure heart, though.
Well, I've done that.
Doesn't matter what their face is.
I've done that where we had a 0 submitted. I had a question. Somebody asked me a question about what happens when somebody has also non-work related Medicare issues and need Medicare. How does that interact with? How does that interact with the MSA or anything?
It should be unrelated, but this goes to Section 111 reporting.
Right.
If the reporting somehow manages to intermix the pre-existing conditions, the treatment for pre-existing conditions could get declined. That's why ICD-10 is very wonderful in how narrow and specific it can be. And that's where you guys should start taking a little bit more notice of what's being reported to Medicare. I would ask in any settlement release that the Section 111 reporting either be shared or at least a specific ICD-10 code that will be reported be included in the agreement. And that way, if something gets denied later on because the coding was bad, now you have a new action.
Tom, I think if you take a case to hearing and I know your initial pleadings is that there was a firm that I dealt with some regularity who always described injuries to their clients as to their back, their legs, and related bodily members, whatever the hell that means. But I would think your initial pleading should be as broadly written as possible so you can catch the entire injury, whatever it might be. But then when it gets to the time to have a judge or a hearing officer or commissioner, whoever does it in your jurisdiction, render an opinion based on a review of the evidence that this is the nature and scope of the injury, try to have them be as precise as possible, because if that case settles shortly thereafter, I think an insurance company would be hard pressed to describe the injury in a fashion other than what the judge said. And the ICD-10 should then strictly comply with the judge's findings and conclusions at the end of the case. So that's sort of
also
a point.
All right, so along that same lines, as we know, we often have, an ATP will say that certain injuries, like a back is related to the on-the-job injury, and then the defense lawyer will send their client, our client to their favorite defense IME doctor, and that doctor says, this is a pre-existing condition and it has not been exacerbated by the on-the-job injury. So at that point, obviously, most likely the defense, the defense people are going to write their MSA saying that body part is not really, the injury to that body part is not related to the on-the-job injury, and there doesn't need to be covered by the MSA, Ryan, like we talked about the zeros. I would say that zero money should be allocated for future medical costs to that body part. What is your thoughts on that? Also, just a quick question also, how do claimant attorneys acquire a copy of the Section 111 report? So that's just a side question, but then come back to mine.
So let me deal with that one first, and Ryan can answer the first question.
Go for it.
The Section 111 filings are submitted electronically. And so I think you may not get the exact submission, but I think at the same time, it would be an easy ask to say to whoever the adjuster is or the claims manager who has that file, please let us know how you describe the injury in the I would almost have that as a standard discovery request. Please let us know how you describe the injury when you file your Section 111. Tell me the ICD-10 codes that you use. Right?
You want this agreed to, you want these Section 111 ICD-10 codes agreed to before the reporting occurs anyway. And that's why I suggested getting it into the settlement agreement. The report, it doesn't matter so much. I've actually seen some, we had the privilege of trying to resolve some liens on behalf of an insurance company a couple times. I admit that with great guilt. It did not go great. But in doing so, I learned a bunch of things, including we got to see some of the Section 111 reports. It's really crude. It's very much just spreadsheet data printed out on way too many pages of paper. Ultimately, you really just want to get this before the reporting occurs. So get it into your settlement agreement, get it into a separate agreement, I don't care. That's what matters, not the actual report. Also, something we've been harping on how specific ICD-10 can be. I know this is a little bit of a divergent topic here, but I want to make this point very clear. ICD-10 is very specific. It is wonderful in how specific it can be. And to that point, and maybe to get a little bit of a laugh in here, there are some very ridiculous codes out there. There is one, V97.33XD, sucked into jet engine subsequent encounter. Number one, you probably can't have a subsequent encounter for being sucked into a jet engine. But number two, really what's important here is that's how specific we are. We can get that kind of coding in existence. If your client's back is hurt, that is not specific enough for me. What part of the back? You can get down to individual vertebrae, low back, mid back, upper back. That's maybe not even specific enough. It can work, but you want to be specific. So if you can say L1, we'll call it a real code here. Use that one. Get that specific. Use the jet engine codes.
Yeah, I had an opportunity to review a stipulation that some parties were going to be submitting to a judge down south who was actually in Mississippi, and claimant counsel, one of you folks, put together the original draft and described the injury as an injury to his client's arm, back, leg, and related bodily members. And they wanted the judge to sign off on that. And so it was, someone asked me to review it, and I said, this is really very poor lawyering. What you want to do, it didn't even describe which arm, it didn't describe which leg, nor did it describe anatomically what part of the back, L4, 5, L5, S1, something like that. And so my suggestion was that you take that, completely rewrite it, and be as precise as Ryan has suggested.
I just want to say,
remember the jet engine.
I just want to say to everybody who's watching, we have about 8 minutes left. So if you have any other questions that you'd like to submit, please make sure to go ahead and do that now.
Yeah, maybe we can flip to our last slide, Tom.
Okay.
All right. Here's some silver linings, we think. If non-submit MSAs ever exhaust, there's no need for Medicare to deny or step in. You know, we see less than 3% of all MSAs in our system exhaust in a year. And so what that tells us is that you folks did a nice job in putting together what the future medical will be, so it gets to the point where they never really exhaust. And I think if you have a never exhaust situation, you're not knocking on Medicare's door asking that the bills be paid.
There is one concern there. Sorry, Paul, there's one concern there. And again, if you get the NSMSA, EBMSA, even if it hasn't exhausted yet, there may be something where Medicare says the Section 111 data is telling us we shouldn't be paying for this treatment. So there is a small concern. Again, this is why I dislike these NS and EBMSAs so much.
Yeah. The other thing you have to understand is our bullet point number 2 is that the Medicare system, like every other system that we operate in, has human beings, and they're not perfect. They make mistakes, and sometimes denials are not correct. And so you should be able to pick up on the denial to see whether it was really correct given the circumstances of the submission and ultimately the denial. If an MSA has some sort of indemnification or guarantee, then they may be a party to pursue when exhausting or other avenues to pursue. We have seen some of the evidence-based MSAs where people have said that they are going to guarantee them or they're going to indemnify them. Ryan and I spoke about this before we were on, and he's never had the opportunity to ask, well, what do you have for coverage that's going to indemnify? And in one instance, I was told that the coverage is their errors in admissions coverage.
This is purposeful. This is not an error. This is not an omission.
Yeah.
They made this decision.
Tom, you and I are in lockstep on that response. And Ryan, you are right. Where is the error? Where is the omission? This was a purposeful choice. And the more important thing is there was some guaranteeing it, that not only guaranteeing it, but representing that we got adequate coverage if there's a problem. Really? I hope you put your carrier on notice.
Because one of my big concerns always was if there was a dispute between, I guess, we had those New Quest products, and we use that term loosely, that if there was a dispute between New Quest and CMS and my client was caught in the middle, what happens if there's some type of litigation or administrative determination as to whether or not certain treatment's covered? While that's going on, if it takes a year to resolve, then my client isn't able to get future medical care for the time while that's going on because nobody's taking responsibility. And that's certainly not a good, I don't think that's protecting our client's interests.
Let me tell you, Tom, there are some good doctors out there, though. And I told you that once upon a time, I took a CMS or Medicare appeal on behalf of a medical group who had treated this little old lady who had a problem and had Medicare. Had nothing to do with workers' compensation, had nothing to do with MSAs or anything like that. But the physician thought it was his duty to treat this woman, did a surgical repair. He did a laparoscopic distant fundoplication was the procedure. And he asked if I ever did any work in this area, and the answer was no. But I said, I'm willing to take a stab at it. And so I took a Medicare appeal on behalf of this physician and ultimately brought it all the way up to an ALJ. I can tell you it took a long time, took several years, and I can tell you further that it was a less than satisfying process up until the very end. And when we got to the very end and the ALJ ordered the payment of the medical bills, it was terrific, but boy, it was not easy. And you guys don't want to have to get in a situation where you're going to try to do that for your clients because it's costly and it's time consuming and it takes a long time. Ryan?
All right, I have a question. Okay. So someone said, my client is 47 and working. Future medical retail is valued at 1.5 million if a life annuity is purchased. Wow. I'm not quite sure if that means the annuity is 1.5 million or if the total amount is 1.5 million. There's a third party case also. Assume the client will work to age 65. Do we need an MSA?
You need an MSA if that future care will be paid or could be paid by Medicare. So assuming this person is not going to be on Medicare until 65, if there's any case-related treatment that is expected after 65, Medicare is telling us you need an MSA, and being as practical and as cautious as possible, you need to do an MSA. The good news is a lot of care that might be happening in the first 18 years of this process is not getting part of the MSA. The bad news is I don't know what's going to be happening after 65, so there's still plenty of future care that probably will need to be looked at.
Yeah. And is that, just to be sure that, and that's because the settlement is over 250,000.
That's because Medicare is not supposed to pay for case-related care at any point, regardless of how much settlement is.
Right, and if the settlement number is that big, and particularly if it's attributable to future medical, given that person's age, I got to believe it's going to extend beyond the age of 65. So I think Ryan's comment is right on point.
Yeah. So
will Medicare review it is a different question.
So you would say an MSA is needed in that situation?
I would think so.
Okay.
Be careful, right? Client's your best friend, protect them.
Yeah.
Okay.
If there's future care that you expect to occur after this person will be on Medicare, the theory is you need an MSA. Again, I understand practical considerations. I understand the settlement value may not get you there, but then that's something to look at. You can say, okay, the settlement's only $100,000. This person needs hundreds of thousands of dollars of care before they're going to be on Medicare. There's no money for an MSA. The settlement will be exhausted prior to Medicare being involved, and that's where you wouldn't need one.
Yeah, we have heard people tell us, Tom, over the years, I haven't spent a penny for medical care for 5 years. I'm getting older. Do I have to maintain my MSA? And our response was, well, why do you have this MSA? What's going on? Well, it turns out it might be a total knee, it might be a total hip or something. Those things fail over time. So it's predictable that you're not going to have treatment for 5 years, but when it fails, or when the screw fails, or when the device fails and you need to replace it, you're going to be out of Medicare aid. So the response to that is protect your health, protect yourself, have an MSA, and pay for that. That second total hip, the second total knee, the screws or whatever out of your MSA. So,
I'll tell you one thing, with a $1.5 million MSA, you certainly want to make sure that there isn't a reversionary interest, so that but that of course is a topic. But that of course is a topic for another another discussion. It's 1 o'clock now. I haven't gotten any other questions. I think our hour is up. So is there anything, Paul, that you'd like to say in closing?
No, I just want to say there will be things developing in the future. There are people who are working behind the scenes on this to get further clarification from CMS. Some organizational groups are going to be doing that. So we may learn more in the future, in the not too distant future, and we'd be more than happy to share that with the folks at WILG. And I want to again thank you folks for giving us the opportunity to ramble on today and give you less than absolutely crystal clear answers to your questions.
Okay, so here, I'm sorry, one quick question. Oh gosh, so now some questions just came through. So Ametros charges $1,000, right? $1,000 the setup fee.
Right.
What about, okay, and, oh, okay. Quickly, what about an individual that's 45 and sells his claim he's not eligible until 65? Are you saying there has to be a set aside when he reaches 65? I would say that the set aside has to be set up when the case is settled, so that, Ryan, you want to just quickly speak to that and then we'll wrap it up.
Yeah.
I agree. If we expect future treatment, or it's, I want to say it's probable. If future treatment is probable, maybe even toward the line of being possible after 65, an MSA is recommended. Again, you get to the question of how much is the settlement. Will that settlement money all be exhausted before he's 65? Then maybe you don't need one, but that's a different conversation where you need very specific information to give a real opinion on it.
I mean, are you saying that right now, based on this new language in 4.3, that basically we have to have an MSA in every case? I mean, even the ones under 250?
You need to have an MSA if there's future medical care that you expect Medicare would pay for whether it's the person being on Medicare now or later.
Can we still use the 200? Can we? For us to write MSAs. Oh, okay. And the answer is somebody's asking about to write MSAs. Can we address that? Actually, that would be something you would go talk to Ryan. You should be Ryan. I'm sorry they're trying to steal your business and send it over to Paul, but
no,
that would be.
We don't do that. We only do professional administration.
The way I always look at it is Massive is involved with everything until the MSA is completed and approved, and then it goes over to Ametros. And that's how their two companies work together.
They're symbiotic.
And it's $2,500 to write an MSA. There's other products that I don't want to go into this too deeply because it's not the point of this conversation. There are other products. We've talked about the idea of submitting 0 MSAs for something around $750. That's where you guys get us that doctor letter saying no future treatment. We'll go submit it to Medicare and get you your protected letter saying $0 MSA. So there's other products, but the general, a real full-fledged MSA is $2,500.
Okay, and I apologize. I understand when you asked to generate an MSA, I misunderstood your question because I knew that Ametros didn't do that. So I apologize for that misunderstanding. Okay, so thank you. Okay, so thank you very much, Ryan, Paul. Thank you to WILG members who participated. Thank you to Melissa and Melanie for handling the behind the scenes, and Jennifer for organizing all of this. So thank you very much. And if you have other ideas for webinars like this, I think if you wrote to Jennifer and let her know, we'd probably see what we can do about setting them up. So thank you very much.
Thanks, guys. Greatly appreciate it.
Bye-bye. Thanks, guys.
Bye-bye.